Thank you very much for the kind invitation to speak to you. My name is Jane McAdam, and I'm a Professor of Law and the Director of the Kaldor Centre for International Refugee Law at the University of New South Wales in Sydney, Australia. I've been asked to speak to you about the 14 Principles of Protection for Migrants, Refugees and other displaced persons in the COVID-19 pandemic. These were drafted in April this year by a small group of international lawyers, including myself, and have now been endorsed by over 1,000 experts and cited by the UN Secretary-General. They are intended as a framework to inform and guide actions by governments and other actors, and to provide a basis for advocacy for people like yourselves. So why are they needed? From the very early days of COVID-19, when the virus had still only been detected in China, we saw racist and xenophobic acts spreading around the world faster than the virus itself. People of Asian descent were stigmatised and subjected to abuse and discriminated against on the basis of their presumed nationality or ethnicity. It became very clear very quickly that COVID-19 was having particularly detrimental impacts on refugees, asylum seekers and other displaced people, regardless of whether they were living safely in resettlement countries or whether they were living in camps or overcrowded settlements where physical distancing is often impossible, sanitation is poor, and testing and medical treatment may be rudimentary or even absent. We started to see refugees and asylum seekers being labelled as carriers of the disease, including by some governments, which only fueled racist sentiments. These situations raised obvious threats to human rights, which were heightened once countries started to close their borders in an attempt to control the virus's spread. As international lawyers, we saw that a number of important legal principles were coming under strain. As governments sought to limit the spread of coronavirus, they dramatically affected people's rights to move freely. While governments are allowed to restrict movement that is necessary to combat a significant public health risk, they must do so within the limits of international law. What happened, though, was that many governments didn't take into account the right to seek asylum or the right not to be deported to a risk of persecution or other serious harm, known as the principle of non-refoulement. Among other things, we started to see boats of asylum seekers being pushed back or stranded at sea, including in our own region. We are now seeing previously unfathomable restrictions on movement globally, including on the right to seek asylum and to enjoy protection. At the start of June, 219 countries, territories and areas had implemented nearly 65,000 restrictive measures, predominantly concerning border closures and entry restrictions. At least 99 countries made no exception for people seeking asylum, which, as I noted earlier, is contrary to international law. As the UN Secretary-General noted this month, refugees and other displaced people are facing three interlocking crises concerning health, socioeconomic conditions, and protection. The need for international cooperation has never been greater. For all these reasons, a number of us felt it was imperative to set out very clearly what international law does and does not permit governments to do. Human rights law exists precisely so that we have some predictability in crises, rather than an absence of law. Law has a role in protecting all of us, and if it doesn't, particularly in a pandemic, then we are all at risk. As the Secretary-General has observed, keeping human rights considerations at the fore ensures better outcomes for everyone. We hope that the principles will be a useful tool for governments themselves, like a ready-made checklist, as well as for others trying to monitor and assess what governments are doing, so that NGOs like yours can hold those governments to account. Even though Bangladesh is not a party to the key international refugee law instruments, it has ratified the relevant human rights treaties, which means that the principles are relevant to the international legal obligations the country has voluntarily assumed. The 14 principles we set out are firmly anchored in international law and practice. The first principle on non-discrimination is key and cuts across everything. But we also emphasise the importance of other rights like the right to health and to information, due process, and non-return to risks of serious harm. All these rights apply to everyone, regardless of their immigration status. The first principle does concern equal treatment and non-discrimination, noting that governments must guarantee equal and non-discriminatory treatment of all people, irrespective of their immigration and citizenship status or the fact of their displacement. Principle 2 is about the right to health and is there to ensure that migrants, refugees and other displaced people are provided with essential medicines, prevention and treatment, again in a non-discriminatory manner. Principle 3 is about the obligation on states to combat stigma, racism and xenophobia, not only by governments themselves, but also for governments to ensure that others don't engage in these negative acts. Principle 4 is about restrictions on movement between countries. Governments are required to ensure that restrictions on mobility adopted in relation to COVID-19 respect everybody's right to leave their country or to leave any country and to re-enter their home country. Principle 5 is about internal restrictions on movement. And again, states must respect the liberty of movement of all people within their territory. Any restrictions must be necessary and proportionate to the threat being combated. Principle 6 is about non-return to persecution and other serious harm and ensuring that asylum seekers have access to territory to claim protection. Principle 7 is about the enforcement of immigration law, including detention. And we note that governments must not enforce immigration laws in a manner that increases the risk of transmission of the virus. And any enforcement must comply with fundamental norms of due process. Detention of migrants, refugees and other displaced people is impermissible where it would expose them to a serious risk to their health and life on account of the pandemic. Principle 8 is about protecting life and health for people living in camps, collective shelters and settlements, noting that governments must take effective measures to mitigate the transmission of COVID-19 in these settings. Principle 9 ensures the right to information, noting that everybody has a right to accurate, current information about COVID-19, including in relation to symptoms, prevention, and its spread. We note that the internet is an indispensable source of information, and so blocking or otherwise interfering with access during the pandemic is not justifiable. Principle 9 concerns the protection of privacy and states that governments must protect people's right to privacy, including their right to control the release of personal medical information. Principle 11 concerns gender, noting in particular that governments must ensure the protection of the rights of displaced women, girls and gender non-conforming people. And particularly, they should identify and mitigate particular threats to such people's health, safety and well-being. Principle 12 concerns marginalised groups, noting that among migrant, refugee and other displaced communities, there may be particular groups who require particular protection, including older people, people with disabilities and children. Principle 13 is about labour rights of workers. And we note that governments must observe such rights, including for migrants, refugees and other displaced people, and take measures to protect their health. Governments must also provide assistance to migrants, refugees and other displaced people who lose their jobs and incomes on account of the pandemic, and provide that protection to the same degree as it's given to nationals of that country. And finally, Principle 14 is about permissible limitations on rights. As I noted at the outset, any restrictions on these human rights must be provided for by law and be reasonable, necessary and proportionate. Rights can't be suspended except in a publicly declared emergency that threatens the life of the nation, and only where strictly required by that situation. If rights are suspended, then they must still be consistent with governments' other obligations under international law.